Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to another episode of Legal Ease, the show that converts legal jargon into legal ease. Now, tonight we'll be discussing something incredibly important, but very little is known about it. And my guest tonight is going to be talking on POPI, and the acronym will be unpacked shortly. But I've had the pleasure of interviewing Advocate Mabel Slubbert previously, but tonight she sits here because she's been a person changing lives for at least 25 years as an advocate. She's also an internationally accredited mediator, an ethics expert, a life and business coach, a human behavioral specialist, and public speaker. She has attended numerous courses around the world on life mastery and law, and specializes in conflict resolution, ethics, change management, relationship and strategic intervention on both corporate and personal levels. Mabel's holistic approach to her clients means that she takes into account all factors of their well-being, including health, finances, relationship, and spirituality. Her monthly champagne talks and tailor-made corporate and family workshops provide practical skills and tools to attendees with a desire to work at bettering their lives, their understanding, and aligning themselves with the law. But remember, I said we're going to be talking of POPI. Mabel, good evening.
Good evening, Ashraf.
And welcome.
Thank you so much for having me again.
Mabel, what's POPI?
Ashraf, we as South Africa always are at the forefront of innovation. And what we have done with the POPI Act, it is the Protection of Personal Information Act. Mm-hmm. And I'm sure as the evening progresses, we'll speak more on that. But for now, POPI means protection of your personal information.
Now, why was such an act necessary, and why did they pass this act?
Well, Ashraf, as you know, that we have got one of the most amazing constitutions in the world. And I'm always proud to say that we have got a magnificent constitution. And in our Bill of Rights, our right to protection of information, as well as access to information, is inscribed. So according to our constitution, we have got a right to protect our personal information, and that is what POPI is doing. POPI is protecting our personal information.
I see you brought a copy of the Constitution.
Yes.
So now, which part of the Constitution would I find my rights protected?
Okay, so if we look at the Constitution, we'll see that Section 14 in the Bill of Rights says that everyone has the right to privacy, which includes the right not to have their person or home searched, their property searched, their possessions seized, or their privacy of their communications infringed.
That's quite a wide range of protections.
Absolutely. We are strongly protected in our Constitution, and then it goes further because this is an amazing document, and you'll see that we find in Section 32 that there is a right that seems as if though it's a paradox. It is the access to information. So the one right protects our information, but the other right is protected, which gives us access to information in Section 32. But
this is a separate act. POPI is one.
POPI is
and
one,
PAIA is
and
another.
PAIA is another one.
So PAIA stands for?
So the one is, the POPI is the protection of personal information, but PAIA is the promotion of access
to Information Act.
Yes.
Yeah. That's quite amazing. So there's two different rights in the same Constitution, one allowing you to access it and the one allowing you to protect it.
Yes.
Okay.
But then, if we go just a bit further in the Constitution, we come to Section 36.
Right.
So what Section 36 does, it shows us when there is a limitation, when we can adhere to the limitation or when not.
So both these rights are limited. That's what we mean by limitation.
Absolutely. And according to Section 36, if we look at that, all limitations on our rights must be passed by Section 36. The rights in the Bill of Rights may be limited only in terms of a law of general application, like for instance, the National Health Act. Okay, so that's general application.
So general application means the entire country.
Entire
basically,
country.
Not a group of people or
Absolutely.
an individual. Yeah.
To the extent that the limitation is reasonable and justifiable, and here comes the big kicker, in an open and democratic society based on, and this is entrenched in our Constitution, human dignity, equality, freedom, and then taking into account all relevant factors, such as the nature of the right. So in this case, the nature of both of these rights, the importance and the purpose of the limitation of the right, and the nature and extent of the limitation. The relation between the limitation and its purpose, so there's a limitation, but then there's also a purpose for that limitation. And then less restrictive means to achieve the purpose. So in other words, is there something else that we can do other than this limitation to have the same effect?
Okay, that's quite interesting. So the limitations clause that you say is in Section 36
Yes.
applies for general application. So it says it has to be reasonable and
Yes.
it has to be in general application. It can't be something that you want to say, I want this to limit your right. For example, let's talk about Poppy, right? Your information is sacred to you. I think that's what you're saying.
It is sacred to me if it identifies me.
Right. So let's unpack that now. You know, what are the components of Poppy? Is it your name? Is it your photograph? Is it your ID number? What is personal information?
So the answer to that question is yes and no.
Okay.
So if it is your photograph without a name, for instance, and you can't be identified, then there's no danger.
Okay.
But the minute we access a photograph, for instance, and you can be identified by that, then there's a protection. So if there's, for instance, only a name like Mabel Slubbert, without an ID number, without a telephone number, then you must ask the question, am I identified?
Right.
Can I be identified by that? For instance, your blood type. Certain instances you can be identified by blood. Then there's a protection.
Now, what is the purpose of Poppy?
Okay, so the main purpose of Poppy is to promote the protection of personal information processed by public and private bodies. And it is to introduce certain minimum requirements for processing this information. Also, it is to establish an information regulator, because there's no point in having such an act if there is not a person that is going to be the body in power.
Right.
So therefore, there's a new information regulator. There's been an office established, and on the 26th of October this year, the President named the information regulator. And that is important information. Why? Because the Poppy Act, there will be a year of grace after the President has enacted this act, and we are expecting it to be around May 2017, But the signal was that once the information regulator, once they were named, we would know that the period of grace would start. So the people have been named, the officers are there, and they are allowed to make regulations.
Okay.
So soon we will have the commencement of this act in its complete form.
Okay. So right now, we're talking of an act that's really coming that will affect you in a big way.
Absolutely.
Okay. Now, who basically is liable for protecting your information?
Okay, so if we look at the Act speaks of a responsible party. So the responsible party would be the person or body that is there to protect your information. It collects your information, it processes your information, it stores your information and shares your information. That is what the Act is about. Also, when and how the information are being shared, as well as the type and extent of information being shared.
Now, just on a practical level, right? If you go to a hotel, and some of these hotels, or let's say even a golf club, they have somebody checking your license and your license disc, as well as your driver's license.
Absolutely.
What are your rights with regard to that information that they've just copied? Because he's not a person or institution in charge, or he's not a police officer. He's just a person manning a gate.
So, Ashraf, the responsible party would be, for instance, the owner of the company, the person that is in charge of the company. Everybody working for or with this company are now liable and should comply with the POPI Act. So even the guard at the gate of the golf course or golf estate now needs to protect your information. If we look at the POPI Act says that you must make sure that you have valid reasons for wanting the information, for needing the information. Personally, I think it's a bit of an overkill that when visiting a golf estate, they should have your name, surname, ID number, registration. Why? Why do you need to collect all of the information? That is the question that you should ask yourself, because by collecting all of the information, you are opening yourself up for claims, whether it be a civil claim, whether it is at various stages of a person's stay in the estate. What will happen to your information? That's the question that the responsible party should ask.
So I think what you're actually pointing to is a thing called vicarious responsibility and liability. So your employees are your extension and you are liable for their actions.
Absolutely.
Now, could you refuse to give this information? I mean, you go up there and you get to a hotel, a building, and the guy says, please sign in. Can you refuse to sign?
Well, yes, of course you can refuse to sign.
But then you don't get entry.
But then you don't get entry. So it's going to be weighing up, do you want the entry or do you want to give your information? And the question that you should ask is, why do they need the information?
Yes.
And how are they going to protect it?
Yes.
Because now it is going to put an onus on them to maybe think of another way. How often have you entered a building where you can see exactly who entered before you, get their registration number and their telephone number? It's opening you up for a civil claim, for instance, according to the POPI Act.
So it looks like there has to be some mechanism in place for people, owners of buildings or owners of businesses, that invite people in and then ask them to identify and give out their personal information. They draw a very heavy onus to protect that information.
Definitely so. So they have to be transparent, why they need the information, and they have to be clear on how they're going to protect that information.
So typically they would say why they need the information is for security purposes. We'd like to know who came into this building, at what time, what is their contact telephone number, what car they were driving, and who they came to see. That's going to be their typical response.
The responsibility is now placed on them to protect that information.
Now, in the example that you gave, it's very interesting when we say protect, because look, you already have this page of 18, 20 people, and you can see who's there.
Absolutely.
They're taking no steps in front of you. On that interesting point, we need to just go for a short break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight I'm joined by Advocate Mabel Slabbert, who is an expert on the field of law known as POPI, or Protection of Private Information. Mabel, just before the break we were discussing a typical example. You go into a building, you give your information, and you have a right to say why they need the information, which is really for practical purposes. Now, your next question is, how do you know that your information is protected? Because that sheet has got 20 names on there, with their ID numbers, with their addresses, with their registrations. How do you know that okay, what should I do with that information if I'm the building owner?
So if you are the building owner, the onus is now on you. As the responsible party. The Act speaks of a responsible party. So the responsible party is the person that collects the information and stores the information and uses the information. So as the responsible party, you now need to put certain measures in place to protect that information. So as a responsible party, I would suggest that you contact me so that I can train your staff. As the responsible party, you have to now take measures so that that information is protected.
So I think on a very serious level, you're saying that people need training to know how to deal with this, in order that you don't get sued, right?
Absolutely.
So let's say I haven't complied, I haven't received training, or I don't want to do. What are the possible implications for me being taken on by somebody who says, you didn't destroy or you didn't protect my personal information on that day that I entered. This information was seen by 2419 scammers, for example. Now?
So there could be a civil claim.
Yes.
As well as criminal charges of 10 years imprisonment as well as 10 million rand. So the fines on that is severe. It's an act that, as you can see, has got teeth. There's no point in having an act and we can't enforce it. That's why we've got the information regulator. And apart from that, the public and the practice, the private and public practices need to know that there are severities that go hand in hand with this act. 10 years imprisonment or 10 million rand. I think it's quite a big fine.
So there must be some very big names in the information regulator. Who, do we know any of the members?
Yes, on the 26th of October this year, the names have been named, and as of the 1st of December 2016, they will take office. This is Advocate Pansy Tlakula, Advocate Cordelia Stroom, Mr. Johannes Weppen, Professor Tana Pistorius, Mr. Sizwe Snail.
Oh, Mr. Snail has been on our show before. He's an expert in the field of IP. And Advocate Pansy Tlakula, we know from the IEC, right? Independent Electoral Commission. Okay.
So as you can see, the information regulator, they are amazing people. And this act, they've spent years working on this act, more than 10 years.
But I must say the severe penalties are quite horrifying.
It is horrifying if you think what people can do with personal information in this day and age. So yes, it is horrifying, and so it should be.
The other example on a practical level, well, at this stage maybe we'll just invite our viewers to call in. The number will appear shortly on your screen, and you can put questions regarding POPI, how you can protect your business, how you can protect your personal information. I think very, very importantly, how to prevent yourself getting sued, because 10 million rand or 10 years in imprisonment is a very, very severe penalty.
Absolutely.
And the act is going to come, and it will affect people that gather information. The other thing is you get calls out of the blue, right? Is direct marketing associations, and so you go onto a website and you sign up and you give out your details, and it's a well-known fact in the industry that this information is sold. Information is actually sold from company to company. Now, who do you hold responsible there? How do you go about it?
So what POPI also does is it has got Section 69, and there are certain conditions which we have to apply with under normal circumstances, but Section 69 of the Act speaks specifically about direct marketing. So in that, there would be extra conditions that you would have to apply with when dealing with direct marketing.
So if I'm a direct marketer, or I give my information out to a direct marketer, is there something that will point out to me that says you can demand that this information not be shared?
Absolutely. So that is what the POPI Act is all about. The POPI Act gives me, as the data subject, the right to say what would happen with my information, whether it can be used or not used. So as data subjects, we have got the option to opt in or opt out.
Oh.
So that makes it a bit different to say that there's an opt-in and an opt-out scenario to this specific act. And when our personal information, when it gets used, we have to give consent, whether it's written or orally. So there has to always be consent from me or any other data subject.
So would that fall under the topic of conditions? I mean, what conditions exist?
So the responsible party
Yes.
could be a public or a private body,
Yes.
and they need to be responsible. Responsible with what? Responsible with the collection of your information, responsible with the preservation of your information, responsible with the third-party access of your information. They must be limited processing, and very importantly, they have to specify why. Why do they need this information? And it has to be a legal reason why. There has to be a limit on further processing. So in other words, if you collect information for a specific reason and the information needs to be passed on to a third party, or in some circumstances where third party access is allowed, you have to have the consent of the data subject.
Mabel, please pause there for a minute. I think we've got a caller. Caller, please go ahead.
Good evening to you and and to the advocate. I've got a question. What must a normal company do to declare certain information privileged, or that could be covered by the actual act itself? Is there a pro forma document you need to keep, or is it in terms of a registry that you need to keep, and who else will keep this type of information to declare this information privileged?
Excellent question. Thank you.
So I will answer that question because unfortunately I need to have a bit more specifics. But in general, information may only be collected for a specific purpose, or for the providing of a service to a particular subject. If the personal information has been collected from another source, the practitioner must inform the subject of this, as well as the source and the purpose thereof. And in your business or in your company, you would have to always say, why do you collect the information? How you are going to store the information, and very importantly, how long you would be storing this information, because there are also regulations that speak about that and that do regulate that.
Does it help? I hope that answers your question. If I take the scenario a little bit further, it's quite important to think how radically things could change. For example, you enter a competition, they say, SMS your name, your ID number, and the answer to such and such, and you could win so many prizes. I'll come back to that point. We have another caller. Caller, go ahead. Hello, we can hear you. Please go ahead.
Hi, good evening. I'm phoning from Pretoria, and I'm watching your show, and I'd like to find out, is the onus on you to prove which company
Mevrou kan maar in Afrikaans praat.
Okay, baie dankie. Ek sal net graag wil weet of die onus nog steeds op jou rus om te bewys watter instansie dalk jou inligting laat lek het.
Die onus is op die instansie om die inligting te bewaar. As jy bewus is van wie die inligting gelek het, skuif die onus nie net na daardie maatskappy om vir byvoorbeeld die pasiënt te laat weet dat die inligting gelek het nie, maar die persoon wat weet dat die inligting gelek het, moet nou ook die beheerliggaam, die information regulator daarvan laat weet.
Okay, baie dankie hoor.
Plesier.
Okay, plesier, dankie. So, sorry, I was just talking, I think we were very deep in that point, but that was a very interesting question. Yes. Doctors, right? Lawyers, accountants, all have information. You're doing a specific transfer, for example, and you have the most important information of this person. You know their name, you have their ID number, you have their ID book, you have the bank account details, you have their company details, you have everything about them. That information has to be protected by the person taking it, and it has to be for a lawful purpose, right?
Absolutely.
Now, what about, let's say I contract with a security company, okay? That security company has got all my details, but that company leaks the information, or it's stolen, or it's taken out of their possession, and it's used for criminal purposes. Let's say criminals then find that information, act on that information, pretend to be members of that company, and then rob you. Do you have a case against the company?
Absolutely. Cybercrime is one of the main reasons why this act has actually been promulgated. So, of course, you have that. The way to surpass that would be, if you are the responsible party, you have to make sure that third-party access is also controlled by you, and that they are also POPI compliant. If they are POPI compliant, which they now should be, even though we have not even entered the period of 1 year grace, if they are POPI compliant, yes, then there could be both criminal and civil charges against them.
That's an excellent point to stop. Please stay tuned. We have to go for another short break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Tonight I'm joined by Advocate Mabel Slubbert, who is an expert in the field of POPI, which stands for Protection of Private Information.
Personal information.
Personal information. Thank you. So we just before the break, I asked you about let's say I had a security company. We received a SMS to that effect. The security company knows all your details, and the security company, as I now understand, has a duty to safeguard that information and not allow a cyber attack or some kind of removal of that information. Now, if that information is used by, let's say, people wanting to rob you, do you have recourse against the security company? Because they came, for example, in a car marked in the security company's details. They had all of your information was absolutely accurate as you would have given it. And they failed, in my view, to protect that information. That's how it could be taken advantage of by thieves and robbers. So what is your recourse?
So one of the conditions of the POPI Act is that when you are a responsible party, as would be the case in this scenario of, for instance, a security company, you have to safeguard the information. You have to secure the integrity and the confidentiality of personal information. And by doing that, you have to take appropriate, reasonable, technical and organizational measures to prevent loss, damage or destruction and or unlawful access. In order to do this, the responsible party must identify all reasonably foreseeable internal and external risk to the personal information. While this information is in its possession and under its control. So it's quite extensive what the Act says on the information. So I think that there's very few, and any Act has loopholes, but I think that this is protected. We are protected as well as we could possibly be by this Act for now.
To me, it appears there's a huge demand for the employers or owners or protectors of this information to educate themselves about it, especially in the age of cloud computing, hacking. I mean, Mossack Fonseca and the Panama Papers is an example of how information can get out.
Absolutely.
I think WikiLeaks is another example of how information can get out. So I don't think there's any sacred cows left when it comes to that. What practical advice would you give to the ordinary South African business owner?
So you have to establish and maintain appropriate safeguards against identified risks and regularly verify that the safeguards are effectively implemented. I would also say that you can appoint a person to keep a watchful eye in your organization, that everybody in your organization, that they are POPI compliant. Also, what you can do as measures would be to identify specific people that would be working with the information. When there's access control, make sure that the access control could be handled from your office as well as remotely. See that information would be encrypted, and regularly check whether your staff, whether they're compliant to the Act. Because, you know, Ashraf, we as humans, we get relaxed and forget that there's a new Act in place. And so we need to be protecting ourselves by being compliant to this Act.
See, again, the scenario that comes to mind is when you go to a public place like a hospital or a doctor's rooms.
Yes.
Now, that information is put on a clipboard, it's sent to the doctor. But if you take a huge hospital, I mean, there's 5 or 6 different desks, different shift changes, and all this information is just gathering there, sitting in files. So how would that employer, what steps would he take? I mean, he'll have to train his entire staff.
All staff should be trained. Measures
but those that only deal directly with the information, surely.
But also those that would deal indirectly with information.
Okay.
Because we don't know where and how a leak could happen. Also making sure that when you deal with other responsible parties. So it's a bit like having a hot potato in your hands, passing it over to the next person. Make sure that the next person that you pass the information to, that person is also POPI compliant. The only time that you would be safeguarded is when the person that deals with the information is not a responsible party but an operator.
Let's distinguish between an operator and not a responsible party, because let me give you another example. You open an account at a store. You put all your information down. You're seeking credit. That's your information. Your bank account, etc., etc., it's all there. Or even if you buy a lotto ticket, you've got to put some means of identification.
True.
The security guard today won 33 million.
Lucky
So
him.
there's a lot of people looking for his information, and his information has to be protected.
Absolutely.
So is there a difference between an institution and what was the other party that you just mentioned?
So just to go one step back.
Yes.
Whether you are a private person or an institution,
Yes.
juristic person, you are covered by the POPI Act. So if you are then dealing with people's information, you would be covered by the Act, unless you are an operator.
Operator, yeah.
So the Act speaks of a responsible party and an operator. So how do we check whether we an operator? If you process data solely in the interest of and on behalf of another person, or you do so only with and in accordance to their instructions, but without coming under their direct authority, this has to be a written contract. And if you would dispose of the data after the arrangement ends, or when you are merely a service provider, and you do not use the data for your own purposes, then you are an operator. In all other situations, you are not an operator, you are a responsible party. And then the Act has huge implications for you.
Quite a frightening scenario.
It is. So the POPI Act is not going to go away.
So I think what you're saying is you must deal with this thing because it's here.
It's here.
It has a huge effect on you, your business, both you as a person giving the information and both you as a person safeguarding it.
And storing it.
And storing it.
And destroying it. Because the Act is also clear on how long you can keep the information and how you have to destroy it. It needs to be destroyed in ways that would be acceptable, SABS approved.
Sure.
And so, because as you know, people can take information from a shredding machine,
Yes.
stick it back together, which is what they are doing, in order to get your information, and then selling it off for 600 Rand for a specific line of information.
Amazing.
Absolutely.
So
amazing.
when you dispose of your old files in the dustbin and
Shredding.
somebody goes and collects this and then takes it to the recycling
to the recycling bins,
plant, yeah.
Absolutely.
That's
So
not adequately disposing of it.
Definitely not. If you go to the recycling bins, you will see how people are standing with papers. What are they doing with that? They are putting it together to see what information they can get. Because here's the thing, criminals are onto this specific type of information. And they are now paying these people
Wow.
to give them reliable information. So if you do shred, make sure you don't just shred like that. Also do a zigzag shredding. You get special machines. They're not expensive. And there's also companies that would do that for you. Those companies have to be POPI compliant as well.
I've seen those trucks, shredders on site.
Yes, shredders.
Time for another break. Please stay tuned. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Tonight I'm joined by Advocate Mabel Slubbert, who is an expert in the field of poppy. Before we carry on, I believe there's a call on the line. Caller, please go ahead.
Hi, thanks, man. I just have another question for Advocate. What are the possible defenses if there's a breach in poppy, either criminally or civilly?
Excellent question. So
Okay,
if there's a
thank you.
breach...
I'll listen on the TV.
Okay, sure.
So if there's a breach, the onus would always be on you as the responsible party. Why is there a breach? And what did you do to protect it? So, of course, if you have got specific measures in place and you can prove that, for instance, you've got encrypted code or there's only so many people dealing with your information, that they have been trained, that they know what the Poppy Act is about, and there's still then a leak, then you would be on the safe side, I would say.
So I think what you're saying, you must take reasonable steps.
Reasonable steps.
As set out there in the Act. But I think it could be quite a cost to the company. Look, let's say you buy off-the-shelf software protection software, you know, the off-the-shelf stuff, and that is breached because, you know, daily you get hackers, you get worms, you get Trojans, you get all of these things infecting your computers. So if you've taken off-the-shelf solutions, is that sufficient? Is that reasonable?
In certain instances, yes. So if you are a company that deals with information that should be protected more than reasonable measures, then of course you would have to take extra measures. But if I'm, for instance, ophthalmologist and I run a practice and I can prove that I've taken reasonable steps, then of course you'll be on the safe side.
I hope that answers your question. But if you have any further question, Advocate Mabel Slubbert's details are available. Mabel, do you want to just give out your cell phone or contact details?
Yes, you can follow me on Facebook or social media. Also, my email address, I would love to hear from you via email, is Mabel, it's spelled M-A-B-E-L, then an extra L for love, then Slubbert, S-L-A-B-B-E-R-T @gmail.com.
Okay. I hope that will inform the viewers adequately about where to find you. Now, what about cross-border? I know that some of this applies across the border, is that right?
Absolutely. So with regards to the Poppy Act, we have to comply within our own borders, within our own laws. But if you are a company or an individual that deals across the borders of South Africa, you must make sure that you comply not only with our acts, but also their acts. And once you deal with people across the border, they have to be compliant with our act.
So if you're a transporter carrying documents of a company, because Poppy covers companies as well, am I right?
Definitely so.
So it covers generics, it covers natural persons as well as juristic persons.
Absolutely,
companies,
yes.
Corporations, trusts.
Closed corporations,
partnerships. So if you're transporting goods and services across to Mozambique, Tanzania, Angola, what do you have to do?
So first and foremost, you have to comply with the Poppy Act of South Africa. Then, once you have complied with that, you have to make sure that you comply with the Information Act of the other country, like for instance Mozambique.
And if they don't have an Information Act?
Well, most companies are now reliant on an Information Act of some sort.
Oh.
So make sure that you find out whether or not the country that you're dealing with, whether they have got an act similar to ours.
Very, very onerous from what I can see and hear.
It sounds as if though it's only that. It is actually very simple to implement. So the first thing that you can do is, I always say the first thing that you can do is contact me so that I can educate
Listen
you.
carefully.
So it lies in the education. You can read the Act. and understand more about the Act in such a manner, and then educate your staff on that. If still you don't know what to do, if you have, for instance, got a specific type, if you, for instance, a doctor or a specialist in a field, what you can do is look at other countries and how they operate and how they've implemented protection of information. Like going, for instance, to the UK or searching what the UK would do in order for them to protect their information if you are a medical doctor, for instance.
Well, the thing that now comes to mind, how do I prove that you let my information out? Let's say I went to 3 places today. I'm doing deliveries at 3 places, and I called at 3 different areas. One of them sold my information. Where would my starting point be? Now, I say my information is out there. People are calling me, selling me life policies that I don't want, or a cell phone that I don't need. And you're busy, and it happens all the time. You get 2 or 3 calls daily, and you don't know how the information is out there, and you ask the caller, you ask the person calling you, how did you get it? And they don't answer. How would you prove? I mean, you have to be a detective, no?
Well, yes, yes, you would have to be, unfortunately, but your first stop would be to check which company that's dealing with your information, which one of those companies are POPI compliant.
Can I use PAIA to ask that company, I want to know from you how you got my information? Can I request
Absolutely.
that?
Definitely so. And you can make sure by checking a company's information to see whether they are PAIA compliant. And the PAIA regulation should be visible.
On the website.
On their website.
Or on a printed form.
Or on a printed form. So that would be your first stop, is to see who did comply and who didn't.
Wow. So there's a lot of compliance issues here. But then, what's the number of this reason? Why is your information so sacred? I mean, you do want to be private. You don't want people to know who you are. But social media has changed all of that, hasn't it? I mean, you have Facebook, you have so many different
It has
platforms.
changed that, but remember that's voluntary. Most of it is voluntary. What this act is to protect information that you don't give out voluntarily.
So that would be a defense, actually, that you actually voluntarily gave this information out.
It would. Then you would have no leg to stand on. So the steps that you can take is to read, identify, and check. The second step would be to check your staff and your premises. What are you doing to protect your staff, how to educate them, and how are you protecting your premises? Then the third step is to assess, create, and implement the Act. And the fourth step would be to identify all the third parties that you are dealing with.
Now, do you like do that service? Can they outsource it to you, that you do a package and give them all of these steps, or train them for that?
Yes, Ashraf. I'm based in Johannesburg, but I do travel throughout the major cities of the country, also abroad. And I then have a day course where I teach staff all these steps that we've spoken of. I break down the Act in understandable language. And if that does not work for you, if you have got more than 5 members that should be trained or taught, or even if you make up a group, then I will travel to you for a day in order for me to educate you on this Act.
I suppose in the event that you sued, those are reasonable steps that you've taken.
Reasonable steps,
that could be a defense.
It could be a defense.
Mabel, unfortunately, we've run out of time.
I can't believe it.
Thank you very much.
Thank you for having me. Thank you.
And thanks to our viewers for having joined us with very pertinent questions. Please stay tuned. In the coming weeks, you'll have more information on this and other topics on Legal Ease. Thank you, and Assalamu Alaikum.